Hi, I am Steve Santhuff. I live outside of Atlanta, Georgia, and I'm here to talk to you about some of the Georgia law that affects the prosecution of people allegedly in violation of the state law. In particular, I possessed a large number of turtles that I'd maintained in captivity for a long time, for private collection, not for sale or business or anything. They were my own personal turtles for my own personal enjoyment. I was successful at breeding them. I maintained them lawfully. I obtained them lawfully. I possessed them lawfully. Didn't have permits from the state of Georgia except for a license to conduct some activities with alligator snapping turtles. But I'm here to talk to you about permits and prosecution of people for wildlife without having permits in the state of Georgia. Okay, there was a man in 1976 who had a gun in the woods. His name was Mr. Howell in Eccles County, Georgia, South Georgia. He got charged by ticket for having a gun in the woods. He got an attorney. He decided, well, having a gun in the woods is not illegal. I'm going to take this to trial. His attorney says, no, it's not illegal to have a gun in the woods, Mr. Howell. Let's go to trial. So they tried to convince the judge in Eccles County, having a gun in the woods is not illegal. You need to dismiss the charges against Mr. Howell. The judge said something to the effect, now I wasn't there, I'm probably speculating. Well, this is Eccles County. We do what we want to. When the game warden says something is illegal in Eccles County, by golly, it's illegal. And game warden says it's illegal to have a gun in the woods. So Mr. Howell got convicted by a jury of his peers for having a gun in the woods. But then when you look to the state statutes back in 1976, you can find nowhere where it's illegal to have a gun in the woods or on a management area. There's more to the story that I'm explaining, but for simplistic purposes, he got convicted for having a gun in the woods. So attorney said, Mr. Howell, we're going to take your case to the Georgia Supreme Court. And they did that. They did just that. They took it to the Georgia Supreme Court in the year of 1976. And this is the entire case. This is not what you get off of a Westlaw. This is what you get when you go to the Georgia Archives in Monroe, Georgia. You get the entire case. Matter of fact, there's some handwriting from the judge in the back of this case where he's convicted. But anyway, what we're going to tell you is this had a very large impact on the Georgia Department of Natural Resources. They were told basically that they could not operate with the current existing statutes that they had on the books. The entire wildlife code had to be revised in the next legislative session of 1977. And with that revision of the wildlife code came this statute in the form of a bill, 27-136, Civil Enforcement by Department. We're going to talk about that in a minute. But we're going to skip back over to this other statute, this other very important statute that came about as well. Oh my goodness, 27-138, penalties for violations. Okay, now I'm going to go back to the first one. I'm going to read you a part of the first one that's very important. Now, I'm not here to talk to you about how clear this language is. I'm only here to talk to you about the fact that it came about as a result of the Howell case, and I'm going to read to you. It says, A, as an alternative to criminal enforcement, pursuant to Code Section 27-138, the Department, in order to enforce this title or any rules and regulations promulgated pursuant thereto, may employ any one or any combination of the following methods. And then it goes on to talk about civil penalties. Civil penalties are fines, other civil penalties. I mean, there's several civil penalties. But what I'm getting at is this statute came about after the Howell case. Now it says, in order to enforce this title, that means it's optional, or any rules and regulations. That's not optional. That is the only way that you can enforce a rule or regulation is through a civil penalty. Now in order to enforce this title, that's optional because you can also enforce the title criminally, or any rules and regulations. It's the only way they can enforce rules or regulations, by a civil penalty. They charged me the same as they charged Mr. Howell with a criminal misdemeanor, 21 of them, for violation of regulations that were not state laws. Not only that, they weren't valid regulations, as discussed in a prior video. Now we're going to read to you the penalties for violation, the 27-138. Unless otherwise specifically provided, any person who violates any of the provisions of this title shall be guilty of a misdemeanor, provided, however, that unless otherwise specifically provided, any person who violates any of the provisions of this title or any rule or regulation promulgated pursuant thereto relating to the possession or use of fishing gear on trawlers shall be a misdemeanor of high and aggravated nature and shall be fined $1,000. For the first offense, $3,000. For the second offense, and $5,000 for the third, and each subsequent offense. Now, what did I just say? I talked about a violation of the title. They can be guilty of a misdemeanor. Okay? The only regulation that can be charged a misdemeanor is those in violation of fishing gear on trawlers. Okay? All other regulations have to be prosecuted based on a civil enforcement by the department. 27.136. All right? In my case, I was charged just like Mr. Howell was. I was charged for violating regulations that were not state law. Now, I was found not guilty by a jury of my peers, unlike Mr. Howell, so my case wasn't able to go any further. But it shouldn't have even gotten into court. So the Georgia DNR needs to start recognizing the civil enforcement and the 27.138, that only a violation of the title can constitute a misdemeanor. Okay? They were told in 1976, but they're still doing it. So I'm just trying to encourage the Georgia DNR to follow the Georgia state statutes. Thank you.